Hi, and welcome to Hull on Estate and Succession Planning. You're watching, and some of you may be listening to episode 205 of our podcast.
Hi, Suzana.
Hi there, Ian. How are you?
Great, thanks.
That's good.
Just came back from a Law Society seminar on file destruction and file maintenance. And interesting seminar. Great. Law Society's come up with a guideline for us in Ontario here on how we can manage those files, and given us some really good heads up on some of the issues. And one of the things that struck me with the seminar was that there isn't an easy answer, and that's what law is all about. And we wouldn't be on that phone call, we wouldn't be at that seminar if we thought there was an easy answer. If the question was just destroy your file at a certain date and walk away, we wouldn't have had to have the seminar. So great guideline there. Highly recommend to people to get on the Law Society, get looking at that guideline if you're interested in that issue. And I'd been fortunate enough to participate as one of the speakers at it and had some fun with the whole issue of special issues relating to wills and estates.
Actually, it's really funny in that you call it the file destruction program, because if I have any recollection of the title of the program, I thought it was file retention. I can obviously see where your bench was.
That's right, exactly. Well, file destruction in the wills area, of course, means it lasts forever, because we have the curse of really, and I mentioned this at the seminar, when you think about it, in this day and age of the electronic age, the only original document that actually matters anymore is a will. There's really nothing else out there. Now, I mean, that's an overstatement. Some crazy hearsay rule of some judge might want to tie in an original document's required, but typically, on balance, the only hard copy document that matters anymore is the will. And it was an interesting discussion we had about that. And a couple of other things came up. But you're right, it isn't file destruction, it's file retention. So, caught me on my grammar, and she's good at that. So let's turn now back into our estate world of ADR and mediation. And we talked about in our last podcast the idea that we are in Toronto anyway, but in many jurisdictions, going to mediation. And we're trying to get people to get the feel of what it's like to be at the mediation day, sort of give you a heads up to what you're getting yourself into. And we ended the discussion on getting the ducks in order, that whole idea. And it's a legal concept, but it's a very colloquial term. What are we getting at when we say for a mediation we want to get the ducks in order?
Well, Ian, as you say, in Toronto anyways, we've got mandatory mediation. And so you're required as a litigant in an estates and trust matter to actually go to mediation. So it's part of the order that you get at the very initial beginning part of the litigation. When you set up the litigation, it's called an order for directions, and will include a provision that the parties must attend for mediation. In other jurisdictions where it's not mandatory, the parties can still choose to go to mediation, and we say that's quite a good choice when you have the right case to do that. And as part and parcel of that preparation for getting ready for the mediation, you want to get the best understanding of your case possible. So you want to have done all your homework. You want to get all the medical records in support of a will challenge, for instance. You want to speak to all the witnesses that are going to make or break your case. You're going to want to speak to the professionals who were involved, and maybe interview the lawyers or the accountants or the investment planners, whoever it is that's crucial to your case. You want to make sure that you've got as much of your evidence and support and the facts supporting your case as possible before you get to a mediation.
And you use that, I love that word, the crucial to your case, because too often people think that we've got to find out everything before we go to mediation. And that's not our experience. Our experience is that we try to get out there and find that core evidence, like, for example, what's the lawyer going to say, or what's the doctor going to say. Bring that to the mediation, so that's not a guess. I don't mind guessing at what the next door neighbor is going to say, or Aunt Molly used to call me, or whatever, but what you don't want to guess on is the core crucial evidence. And that ties into the next part, and that's sort of the legal concept, is that getting the ducks in order, and that is everyone there with a financial interest. You mentioned that at our last podcast, and you talk about it because in our order for directions, we have started the lawsuit by chasing down everyone with a financial interest, chasing down anyone named in prior wills, making sure they're all on notice, making sure those on an intestacy are on notice, so that we can say to the mediator, you know what, we've invited everyone, and if they didn't choose to come, that's okay. We're going to still press on.
And sometimes that's actually a hard thing for clients to understand the importance of that, because they just see it as more money being wasted because you're bringing more and more people to the table. But the truth is it only takes one person to scuttle a deal at the end of the day. So one person can stand up and say, wow, you guys settled an estate, but I wasn't there, and I have an interest or I have a claim against the estate, I should have been there. And then that whole settlement can go by the wayside, and all the time, the energy, the resources expended in getting to that stage are going to be totally wasted.
And the classic example of that is when people don't invite, for example, if there's a situation where minor children have an interest in the will, and they don't tell the Office of the Children's Lawyer here, the Children's Advocate, the government agency here in Ontario, they don't tell them, and you have a mediation, and you get a deal, and you put it to them, and they say, well, you know what, if we were there, we would have said this and this, and we're not going to take that deal. You can have just scuppered all of your efforts in it. Now, the other part of that is, so let's presume we've done our good work, and we told everyone that needs to be there, and we put them on notice, and those people are told about it. One of the other twists that we find is that we push back a little bit if we know that someone isn't going to show up. For example, if one of the parties says, I'm only sending my lawyer, I'm not coming myself, or one of the sisters says, I'm not coming, but we know that sister is actually a crucial element. Maybe not legally, but maybe one of the people can tie this thing together. Maybe she's the one who's in the middle and helps hold this thing together from the outside in. Those kinds of things. And often what we'll do is, before mediation, is we'll find out, test the waters. Who's coming? Who's not coming? Are you bringing your wife? Are you bringing your husband? Is that going to upset people? Who's at the table? And sometimes I'll go as far as to say, draw a little map of a table and say, okay, who's going to be sitting there? And let's talk it through at our pre-meeting that you talked about. Let's talk about who's going to be there, who isn't going to be there, and if they should be there.
Right.
All right, so we've done the legal angle on it, who's going to be there. We've done the practical side of who should be there, and now we've got everyone at the table. So we're sitting at the table, and the mediator's at the end of the table. The hourly clock is on, and away we go. We talk about the open session. Now, the open session is dealt with in different ways, and let's talk a little bit about the open session.
Well, the open session, really, the purpose of it, I see it to be anyways, that you've got the mediator who's going to introduce his or her understanding of the case, and it's an opportunity to make sure that the mediator understands the nature of the case, understands what the parties' respective positions are, and understands the crucial facts. I don't necessarily think that the mediator is expected to know every single fact, because the truth is, at the end of the day, it doesn't matter. But even stepping back from that, it's just not possible.
Yeah, not realistic.
And same with the trial, mind you. At the end of the day, a judge doesn't necessarily know every other fact either. But that's a different, whole different ballgame.
Yeah, but you raise a good point. And that point there is that we sort of laugh sometimes. But I mean, judges make decisions on a very small part of the case. No matter what people say, they only know a small part of the case. They've only heard a little bit. Same problem with the mediator. So to the extent that we're advocating, we don't want to dump tons of information at that mediator. The mediators are only so smart and have only so much retention. And so we've got that one day, and we want to, again, we talk about the crucial witnesses. I don't want to fill that mediator's head with what Aunt Betty is going to say.
Right.
If Aunt Betty doesn't mean anything to this case, but it sort of grinds at the other side, I don't want to waste people's time. I want them to know what Dr. No says.
And the key thing that I think in terms of preparation, Ian, that we didn't mention is how important a good mediation brief is. And I think you're getting at it by highlighting the kinds of evidence that is really going to get a mediator excited, and that's the kind of stuff that we want to make sure we put into our briefs for our clients' benefit.
Absolutely. And we don't, again, let's put on our hat as mediators, and we find that if we get sent stacks and stacks of materials, we'll read them. First of all, it's at the expense of the people sending them, but more importantly, the expense aside, is that, well, again, what are we going to retain? We want to retain the crucial elements of it, and to the extent that we can be sent to that direction, or that when I mediate, I point the mediator to that direction as fast as I can. Even if the materials don't jump out, and I can tell because the mediator either has just not got my pitch, at that open session, I'll say, I look forward to chatting with you in caucus, not in front of everyone else, because it'll just stir the pot. I want to chat with you in caucus and tell you a little bit of some of the highlights, but let's get on with the show.
Yep, and I mean the truth is that first session probably has to be managed very carefully by a good mediator, because you don't want to inflame the situation any more than you already probably have with mediation briefs that could be a little bit more inflammatory than otherwise, just because that really is the first moment when the client really feels that they've had their say, apart from their affidavits that they've prepared in advance. This is their moment to sort of put a culmination of their case before someone, and they get their best foot forward from their perspective. So to be able to sort of step out of that and have a mediator say, okay, I understand your positions. In caucus, you can really explore that a little in much more detail, give you that opportunity to have your say, but for the purposes of the opening session, let's just take it and rise above it.
And it's interesting you say, because I was at a mediation with one of our juniors lawyers, and a great mediator. We settled the case, but at the end, the mediator looked at us and said, what was wonderful about this whole mediation was neither lawyer inflamed with their brief. And they said that really was a big leg up to getting the process of healing going.
I think so. That's so true, because it's such an emotional kind of day.
Absolutely. Sorry, I interrupted you on the emotion. We got a double emotion there. All right. So listen, thank you so much for joining us today. It's been a lot of fun having you back. Welcome. We've got a busy time coming up ahead, so we'll have some more interesting reports of what's happening on the field, and we've got some more discussion maybe we can work through. We're going to talk about maybe a bit about the choice of mediator in our next one, and then work through a bit more of the mediation day.
Great.
We're getting a perspective of the mediation day.
Super. Thank you very much, Ian.
Thanks, Suzanne.
Thanks.